Well, hello, everybody, and welcome back to Raw Law Unfiltered with your host of the DUI Guy Plus. Today, we are going to continue the saga that we started right before the new year. Only this time, we're going to be taking it from the other end. No pun intended. The Amber Heard getting sued by her own insurance company. Getting sued, getting screwed, getting the shaft, all of the above. That's exactly what AH, our lovely protagonist in this scenario, is getting. If you all remember, the last time we talked about it, we talked about the lawsuit that was filed by New York Marine directly against Amber Heard. Now, running parallel to that, we also have another lawsuit from the previous year where Travelers, another one of Amber Heard's insurance companies, decided to file a lawsuit against New York Marine themselves, saying, pay up, busters. She had a policy with you too. You also are under a duty to defend, under a duty to indemnify, and under a duty to basically pay up. And her insurance, or former, I guess you could say, insurance company said no. That's New York Marine. So Travelers versus New York Marine. Both of these cases, by the way, New York Marine versus Amber Heard and Travelers versus New York Marine, both are in the Central District of California. So if you want to look them up on Pacer, you're more than welcome to. Thank you for joining as a member. Missy, don't forget to like this video, comment below, subscribe to the channel if you haven't already, and let's go have some fun, shall we? First and foremost, as you can see, like I said, for the Central District of California, this is United States District Court. It's a declaratory judgment. Equitable contribution of defense expenses is the request for Travelers of New York Marine, as I've already indicated. So the introduction. Travelers Commercial Insurance Company alleges that New York Marine and General Insurance Company, ProSite is what they're going to call it, they had a failure to meet their obligation to provide it and Travelers Mutual Insured, which is Amber Heard, the California resident, with independent counsel to defend the insured in the underlying defamation action, and is a breach of its insurance policy and its obligations. It therefore unfairly forced Travelers to pay ProSite's proper share of defense costs. So basically, what Travelers is saying is, look, New York Marine, you are equally responsible for paying for the defense costs that we have been shelling out. Now you need to catch up on your obligation. And they failed to do so. That's why they're suing New York Marine. Travelers has been damaged monetarily by this conduct and is entitled to judgment in the form of a declaration that ProSite was obligated to provide the mutually insured with a proper defense, and they failed to do so. Moreover, under the doctrine of equitable contribution, Travelers is entitled to reimbursement from ProSite of at least half of the monies that Travelers has spent so far to defend their mutual insured with proper counsel and adequate experts and vendors. Now, jurisdiction and venue, we're going to skip over that. That's all proper, over $75,000, blah, blah, blah. Yes. The Travelers policy, here we go. Travelers issued a homeowner's policy number such and such to Amber Heard for the policy period beginning November 14th, 2018 and ending November 14th, 2019. The Travelers policy was issued, and by the way, pay attention to the fact that Travelers policy was taken about 1 month before the op-ed was published. Curious stuff. She took out this policy literally minutes before it was published, figuratively speaking. Before the op-ed was published. That's kind of curious. We talked about like trying to defraud an insurance company at the last live when we talked about this stuff. So I don't know. It's a little hairy. It's a little funky. You be the judge. Is there insurance fraud here by Amber? Travelers policy was issued and delivered to Amber in California, and it provided coverage by the traveler's policy and extends to otherwise covered or potentially covered damages because of defamation, which is obviously, as we know, the case at hand. Traveler's policy promised a defense to any lawsuit seeking such damages. Now, the pro-site policy, this is New York Marine. Pro-site issued commercial general liability insurance, policy number such and such, July to July, 18 to 19. Pro-site policy was issued and delivered to Amber, also in California. The coverage also provided extended otherwise to cover damages because of defamation. And this is why we are suing for damages. Now, the underlying defamation action, on or about March 9, 2019, Amber, the California resident, was sued in Virginia State Court, which is going to be called the underlying action. And the lawsuit seeks damages for defamation potentially covered under the traveler's policy and the pro-site policy. So each owed the mutually insured, meaning Amber, a defense from the date the action was tendered to it. Travelers, of course, responded to the tender. They provided her with a defense. They paid, and Travelers has paid the fees of the mutual insured and independent defense counsel. But pro-site responded with, we have no obligation. We're not going to pay. We're not going to defend. We're not going to indemnify. And now Travelers is coming after them. This is a discussion of how they were going basically back and forth. And pro-site, this is interesting, compounded its breach of its duty to defend by having its appointed counsel do next to nothing and simply piggyback on the work of the mutually insured independent defense counsel paid for by Travelers. So basically what they're also alleging is that not only did New York Marine not pay, they also kind of were like, yeah, we're here, you pay and we'll pay later, and piggybacked off of the defense that Travelers has provided Amber Heard with in Virginia. New York Marine's appointed counsel withdrew from representation on November 20th, 2020. And then on January 21st, 2021, advised Travelers, New York Marine advised Travelers that they will pay 50% of the fees, costs incurred by independent counsel on and after November 20th, 2020. Travelers acknowledged pro-site's agreement, but demanded that pro-site also pay the same percentage for fees and costs incurred by independent counsel between the date of the tender to pro-site and November 20th, 2022. But to date, pro-site has not paid any portion of any fees or costs incurred by independent defense counsel in defense of the mutually insured, and that such is the same to this day. To date, pro-site has not reimbursed Travelers for any portion and indicated that after trial, it will likely attempt to deny coverage for any award against the mutually insured based on its reservation of rights. New York Marine has most recently argued that its defense obligations should be determined under the law of Virginia, despite having repeatedly invoked California law in its communications. Now, that is a bit odd, but maybe justified. Now, of course, they're calling their conduct deceptive, should not be tolerated. Travelers wants to be reimbursed for having to defend Amber Heard. They believe that pro-site is obligated to reimburse Travelers for at least 50% of the independent defense counsel fees and costs plus interest, and further obligated to pay at least 50% of those fees and costs going forward. Now, first claim for relief is a declaratory judgment. Remember, since this is a battle between two insurance companies as to whether or not monies are owed under a policy, it's not really a lawsuit in like the strictest sense of the term as you think lawsuit. When you file a suit against someone and you're like, hey, you broke my arm, now pay for my arm, is a little different. You know, this is kind of like you're asking the court for a declaratory judgment, which is just a fancy word for make them do what they said they would do under the policy. That's it. No magic here. There's a host of issues about the reservation of rights. And of course, Travelers seeks to seeks the following declarations against New York Marine as to their duty to defend. You know, this is all going to sound familiar. If you haven't seen the previous video, by the way, that I made, Amber Heard is in deep doo-doo, go check it out. It should be in this playlist below the video above, below, whatever it is, the last one that I did in this series. Fascinating video, absolutely fascinating, especially because, don't forget, we're also covering the New York Marine lawsuit directly against Amber Heard. This is the two insurance companies battling it out on the underlying Amber Heard bullshit, right? So the duty to defend with independent counsel. This is all going to sound very familiar to you. Breach of its duty to defend. If you've seen that previous video, if you have not, go check it out. Obligation to reimburse, obligation to pay fees. I mean, this is all standard. They basically, they want money. They want compensation for the monies that they had to pay out to defend Amber in her lawsuit. And now Travelers is like, look, we paid all this money and you, New York Marine, said you're going to pay and you're not paying. So WTF. Pixie Doll says, I can't wait to see her lose again. Well, we'll see. We shall see. Missy says, oh, it's a treat for the kiddies, which, by the way, I bought this thing called, is it something Pure Talk? What is it called? Fluent Pet. Fluent Pet. It's those buttons that cats and dogs press to like communicate with you. I'm going to see if I can train her to train me to do that, because I'm not training her. She's going to be training me. You think you're training them, but the reality is, I think it's the reverse effect. But I'm okay with it. I'm okay with it. I'm gonna be very happy. Anyway, back to the lawsuit. The second claim for relief by Travelers against New York Marine on behalf of Amber. They're saying there's an equitable contribution of defense expenses in the underlying action. We paid this money. They each owe the insured a defense, a duty to defend, and they cover the same risk. And Travelers, I think the more I look at this case, the more I start to think, I think Travelers just feels like a moron. Honestly, I think Travelers just feels stupid, because Travelers could have done the exact same thing that New York Marine has done and been like, no, we're not paying until, until this case is over. And, oh, look at that. You were liable and the jury found actual malice, which means there was intent and it's intentional tort, and we don't cover intentional torts. I mean, in theory, Travelers could ask for a refund, but good luck with that, getting money that Amber doesn't have from her for their failure, for the fact that they have paid. New York Marine took the smart way out. New York Marine was like, look, we're not paying jack shit. Come after us. And they're probably going to win, like I said. And Travelers just feels like, damn it, we should have done that. We're idiots. But now we have to go after New York Marine because we are the idiots that paid. And now we're hoping to recoup at least some of our expenses. 50% is the most that Travelers can get from New York Marine. Okay. Now, Amber obviously countersued, again, going back to the previous video, Amber countersued New York Marine saying, pay up everything that you owe. So both Travelers and Amber are coming after New York Marine, and New York Marine in turn is coming after both Travelers and Amber Heard. So there are two separate lawsuits. Like I said, we covered the first one in the first video, and now we're covering the second one. They're completely two separate causes of action that were two different complaints by two different parties, filed against two different defendants, filed on two different dates in two separate years. This one is from 2021, and it's still ongoing. Both cases are set for a conference this Monday at, I believe, 1:30. Hi, baby. You want to say hello to the chat? She wants to say hi to the chat. Come here, baby. Come here. Oh, yes. Oh, yes. She's getting so big, you guys. Have you noticed how big she's getting? Hi. She always likes to say hello to the chat. Hi, chat. I am Zinni. I'm a big kitty. You're going to be talking to me soon. I know the food button is probably going to get pressed the most. It's going to be like, food. See, she's already looking for it. She's like, where's that button? You keep talking about it, Human, but you're not showing me the button. Where's the button? Will Amber have to appear if it goes to trial? On the other case, yes, not on this one. I can't wait to see her lose again. I think I already highlighted that one. She's literally like gonna fall asleep. Isn't she so fucking gorgeous? I swear to God, you guys. Look at this face. Look at this face. Ah! Her whiskers. Oh, okay. Are we going? We're going. All right. Bye-bye. She's like, all right, I said hello. Enough of that. So, duty to defend. Now, Travelers spent and continues to spend. See, this was before the trial when this complaint was filed. This was or maybe in the midst of trial. They amended it, I think, April of 2022. Spent substantial sums towards the mutual insured's defense in the underlying action, with independent defense counsel of the mutual insured's choosing, as well as other counsel, experts, vendors, etc. For its part, rather than paying half, New York Marine decided not to reimburse Travelers at all and has not adequately funded a defense of its own. They demanded they get reimbursed. They are claiming that ProSite, which New York Marine, owes it, but refused to reimburse. Wherefore, they asked for an order of judgment against ProSite, declaring that they have a duty to defend. They have a duty to defend with independent counsel. They breached their duty to defend. They must reimburse Travelers, and they're obligated to pay fees and costs incurred by independent counsel going forward. They want to enjoin New York Marine from refusing to participate in the defense, basically force them into the case, which is unprecedented. Award Travelers a money judgment and 10% interest. Okay? Now, New York Marine responded to that and filed their own counterclaim. Okay? That was the complaint, the amended complaint. This is the amended answer. New York Marine comes forward and responds. And of course, we're not going to go line by line here. This is just standard stuff. They're going to deny all the relevant portions that they believe are deniable. And they're going to admit all the allegations that they believe are admittable. So anywhere where New York Marine, Travelers Insurance states basically an undeniable fact, like New York Marine is an insurance company. Like they're not going to be like deny, that'd just be stupid. Like you're denying that you're an insurance company. No. Yes, we admit that we are an insurance company. Yes, we admit that we had a policy with Amber Heard. Yes, we admit that we have failed to pay, but we deny the allegations that we are under a breach of duty. We deny the allegations that we have a duty to defend. We deny the allegations that we have a duty to indemnify. We deny the allegations that we have to share and reimburse costs with Travelers. Okay? Very, very important. So that's basically what we're doing, what they're doing in the initial paragraphs. Welcome, Michelle Green, as a member. Thank you very much. And welcome, Jessica Cantors, as a member as well. Welcome to the channel. So answering paragraphs 1, 2, 3, 8, 9, etc. Like I said, this is all just boilerplate stuff. You guys will be falling asleep if we go through each and every single one of these line by line. So I want to spare you and get to the fun stuff. The affirmative defenses. Okay, now this is the meat of the response. And then we're going to get to the counterclaim by New York Marine against Travelers. So first, they're saying that, first of all, they failed to state a fact sufficient to constitute a claim upon which relief may be granted. So basically, you completely screwed up, Travelers. You don't even have a right to recoup anything because you fucked up the entire complaint start to finish. Second affirmative defense, they're saying that because plaintiff lacks standing to assert claims on behalf of Amber, they have no right to assert these claims in the first place. This is something that Amber needs to assert. That's a very interesting one. Like you don't have standing. Thirdly, They are barred because they failed to name and join all necessary parties, so they're missing some parties, potentially. Fourth, New York Marine alleges that it acted in accordance with the terms of its policy and applicable law, and neither plaintiff or its insured are entitled to benefits under the policy because they failed to satisfy conditions precedent to coverage, including failure to cooperate with New York Marine and its appointed defense counsel. Remember, it's very important because they brought in their own counsel. Amber said, no, I'm going to bring in my own. And New York Marine's like, well, okay, we're not paying for that. Fifth affirmative defense, New York Marine has reasonably performed and discharged in good faith each and every obligation, so go away, travelers. Sixth, New York Marine's actions with respect to plaintiff and the insured were done in good faith and consistent with business practices and necessity. Seventh, New York Marine did not either directly, legally, or proximately cause or contribute to plaintiff's damages, injury, or loss. They did it to Amber, not to them, right? It's actually the sixth one, or the seventh one is I think the most fascinating, because they're like, we don't owe you anything. You chose to insure Amber, under your own policy. But remember, Traveler said that there is a piece of paper out there that basically is signed by New York Marine saying, oh, yeah, we will pay. We will pay. And they chose not to. So I don't know. That one kind of stinks, but it's interesting. Under the doctrine of laches, this is an ancient doctrine that is almost never used, but they're trying it here anyway. Ninth affirmative defense, New York Marine's appointed defense counsel fully participated in the defense up until the withdrawal November 6th. We don't owe you anything. Moreover, it was Travelers and their intentional conduct to deliberately encourage Amber to basically get rid of New York Marine's counsel. Therefore, we don't owe you anything. And they contended Travelers had the unclean hands. Unbelievable. 10th affirmative defense. Plaintiff failed to mitigate, minimize, and avoid harm by continuing to simply pay. We don't have to rescue you from your bad decisions, Travelers. That's what the 10th one says. That's your own personal business decision. You screwed up. We don't owe you anything. 11th, New York Marine does not have any obligation towards plaintiff or the insured, and that has been excused. 12th and last, New York Marine is entitled to offset against any amount awarded to plaintiff on account of the First Amendment amended complaint and for each causes of action incurred by New York Marine in the defense of Amber Heard and for sums already paid to the plaintiff. So basically they're saying everything we already paid, we're also entitled to recoup back, by the way. All of this aside. Lovely. And they reserve the right to have any more additional defenses. They ask for relief. We don't owe anything. We're not going to pay anything. Leave us alone and award us a judgment for attorneys' fees and so on. Now the counterclaim. As in all good things, New York Marine brings forth its own allegations against Travelers. Defendant, counterclaimant. So now they're like, the V is flipped. Now New York Marine is at the top again. Just like Amber did to New York Marine in the other lawsuit, New York Marine did the same thing to Travelers. Here are the allegations. You had this policy that we just talked about. New York Marine had this policy, which we talked about. Underlying action, this is all a repeat. On September 4th, 2019, insured tendered the underlying action to New York Marine. Upon information and belief, the insured also tendered the action to Travelers on the same date. New York Marine accepted the insured's defense, and subject to a reservation of rights, appointed a law firm, and expressly instructed the firm to act as lead counsel. Travelers accepted the insured's defense. They agreed to assume the insured's defense in the underlying action, subject to a reservation of rights. Also, offered to provide the insured with independent counsel. And they basically both moved forward with their own counsel. But in June 2020, the insured replaced the Kaplan firm with Virginia-based licensed attorney Elaine Bredehoft. A lot of you may remember that name, right? So Elaine comes in and they're saying, look, Travelers permitted the insured to switch, but we didn't agree to this. Their obligation to pay fees of independent counsel selected by the insured is limited to the rates which are actually paid by the insured to the attorneys retained. So they're saying we don't owe you anything. Specifically, on or about June 10th, Travelers entered into agreement with independent counsel, pursuant to which independent counsel was permitted to bill its usual and customary hourly rates. So now you have Amber and her counsel and Travelers making a contract amongst themselves. And New York Marine is saying, look, we're a part of this. We don't give a shit what you did. We don't owe you anything. There was no limitation on those accounts subject to a purported agreement. This would constitute a capped fee of $2.5 million through post-trial motions, not including appeal. And as of February 2021, independent counsel has exhausted the purported fee of $2.5 million. Think about it. Elaine Bredehoft and her law firm, between June of 2020 and February of 2021, have earned a fee of $2.5 million. This is a year and 2 months before trial started. So I remember people saying like the fee that has been earned by Elaine Bredehoft and the rest of the defense team, somewhere around $6 million. It's probably more than that. It's probably more than that. If you count, June to February, that's about 8 months. February to October would be another 8 months. That's another $8.5 million. Oh, excuse me, $2.5 million. And then October to April, that's another 6 months. Let's call it another $2 million. What is that? 7 now. Plus the trial. That's probably like $10 million. That's about a $10 million bill that Amber has racked up in her defense action. Now, not all of it is being paid by Travelers, of course, but at the end of the day, somebody's fronting the bill. I don't know who. Is it Elon Musk? I don't know. Somebody's got to be paying because they kept defending her. So on May 18th, 2021, Travelers entered into a new agreement with independent counsel, pursuant to which it vitiated the original purported capped fee and agreed to pay independent counsel ongoing fees and costs. As a result, on information and belief, Travelers has incurred in excess of $5 million in defense fees and costs in connection with the underlying action, far in excess of the amounts which Travelers was required to pay under a contract that they decided to sign by themselves. Don't forget when this was filed. This was filed March 25th of 2022. This was a month before trial. Travelers was already 5 million deep. More than 5 million deep. Now, trial is a very condensed version. So, I would venture to say that, 10 million is probably an accurate number as to how much her defense cost, including the trial. And Travelers reimbursed at least 5 of that, if not more so. Maybe even the full 10. If you remember remember Pamela Johnson from Travelers Insurance? She was the one that was seated at counsel table, or not counsel table, was seated in the gallery. She's the one whose computer screen I was able to see, if you remember. It's this lady right here. Come on. It's this lady right here. That's her. Shush. Okay. So she was the one who had the computer open in court. She's the one whom I've seen the screen from the $25,000 payment to Gordon and Reese, if you remember. That was a very interesting moment. Somebody said, like, I had a photo. I've taken a photo of it. Bullshit. Show me the photo. Show me the receipts, bitches. Yeah, I never took a fucking photo. These eyeballs took the photo. And I wrote down the information in my notebook. I think it was Robert Barnes who populated the whole idea on like Viva Frey's channel. Unforgivable. Spreading rumors and false information. I'll never forget that. Anyway, let's get back to our story here. Okay. So she's in the front row. She has been there the entire time. She has been there throughout. Every day that I was there, she was there. So travelers continued to indemnify and defend Amber in this action, shelling out monies, probably thinking she's going to win. We're going to recoup expenses. Johnny's ship is going to sink, no pun intended. And we're going to come out victorious. And little did they know, Amber was about to nosedive in popularity, both on the social and the Hollywood spectrum. And her ship was going to sink and tank. Well, so following this, independent counsel that was retained by Amber and funded by Travelers consistently refused to cooperate with Cameron McEvoy, which was the firm that was given as a defense for Amber by New York Marine, obstructed and prevented them from active involvement in the defense of Amber. And specifically, independent counsel retained by Amber and funded by Travelers frequently omitted Cameron McEvoy and its attorneys from communications with the court, opposing counsel, and case-related emails. They basically shunned them out completely. And now they want payment? Get the fuck out of here, right? Like, this makes no sense. On or about August of 2020, the Charleston Bredehoft firm entered into a stipulation to continue the trial without including that same firm, not notifying them that such a stipulation was contemplated, and didn't include them at all. Travelers has inhibited, obstructed New York Marine's ongoing participation in the defense, thereby basically instructing and encouraging independent counsel not to share any information, invoices, status reports, relevant information with New York Marine despite their requests. Now, that's very important. That's extremely important. New York Marine is saying, look, we want to participate in this. If you want us to pay, let us know what we're paying for. And Travelers was like, no, we got this. We got this. But now Travelers like, but you got to pay. But we got this. Don't worry about it. But you got to pay. But don't worry about it. Like, we got this. But you got to pay. Okay? Like, on what universe is Travelers living on? I don't understand. Travelers was aware that independent counsel refused to cooperate with New York Marine's firm, Cameron McEvoy. And indeed, there was an email on March 21st, 2020 that was sent to attorney Sean Roche of Cameron McEvoy, because Pamela Johnson, there's that lady's name, the assistant vice president, the claims professional, intellectual property business torts, who was responsible for handling the underlying action on behalf of Travelers, expressly acknowledged that she had spoken to independent counsel about billing, sharing work, etc., and stated that her conversation with independent counsel did not go well. Oopsie. Notwithstanding Travelers' March 2020 conversation with them, independent counsel continued to refuse to cooperate with or facilitate Cameron McEvoy's active participation in the defense of the underlying action. Therefore, Travelers failed to insist that independent counsel cooperate and with a full and active participation with Cameron McEvoy. And as a result of their refusal to cooperate, we don't owe you jack shit, and please go away. And they withdrew, obviously. So the first cause of action in their counterclaim against Travelers, we did not owe you a duty to defend Amber through independent counsel, as has already been discussed ad nauseum. Virginia does not apply any legal presumption that defense counsel retained an insured to defend an insured under reservation of rights will do anything in the conduct of the insured's defense which is inconsistent with the insured's interest. You, Travelers, decided to incorporate and include your own independent law firm to represent Amber and shunned our law firm out. And New York Marine is informed and believes, based on the allegations in Travelers' First Amendment complaint, that actual justiciable controversy exists between New York Marine and Travelers as to those matters. And therefore, we don't owe you anything. New York Marine has no obligation to defend the insured through independent counsel under California law, whether pursuant to the Civil Code of California or any other California provision. Secondly, New York Marine did not fail to provide a defense to Amber. New York Marine, under a reservation of rights, did not give rise to any obligation to provide Amber with independent counsel in connection with the defense in the underlying action because they reserved their rights. And again, New York Marine is entitled to a declaration that it did not breach its duty to Travelers because Cameron McEvoy firm was originally retained by the insured and they have been excluded. Now, they also won reimbursement, and we're not entitled to give them the reimbursement. New York Marine reimbursed Travelers for 50% of the fees and costs it incurred if in funding independent counsel retained by the insured, and thereafter participate with it in funding independent counsel on a 50-50 ongoing basis. Travelers has wrongfully contended that New York Marine owes a duty to do so. And in agreeing to defend the insured through its own independent counsel, Travelers failed or refused to exercise its right to limit amounts paid to independent counsel to the rates which are actually paid by Travelers. Remember, they said $2.5 million cap, and then they literally just decided, you know what? We're going to open the caps. Feel free, charge more. We will pay for it. And now they're asking New York Marine to indemnify. Thank you, Terry Carson, for the super chat. I mean, that's just ridiculous. That is literally ludicrous if you really think about it. Travelers was aware that independent counsel consistently refused to cooperate with Cameron McEvoy, so why should we pay? And as a result of the inequitable conduct, Cameron McEvoy firm withdrew from the defense on November 6th. Nevertheless, despite numerous repeated requests from New York Marine, neither Travelers nor independent counsel has provided New York Marine with copies of anything. And thereby their conduct in entering into improvident, fancy word for just, we are not part of it, agreements with independent counsel, we don't have to pay. That's a you problem. That's not a we problem. You're trying to make it a we problem, but it's not a we problem. That's a you problem, New York Marine. Under California law, where an insured properly offers a defense through appointed counsel and the insured refuses the defense, neither the insured nor the insurers which fund the insured's defense may recover from the non-participating insurer for sums incurred to defend or indemnify the insured. New York Marine is entitled to recover any additional amounts which it pays to Travelers. So what they already paid, they may be entitled to reimburse. And New York Marine is also entitled to a declaration that they are entitled to reimbursement of $621,000, $691,693.43 previously paid to Travelers on or about January 18th, 2022. So they also want that reimbursement of $250,000, plus any additional amounts paid to Travelers in reimbursement of defense fees, costs incurred after November 6th withdrawal. And Travelers is not entitled to recover anything else from New York Marine And of course, they want a declaration from the court. Just beautiful. This was about 10 months ago. This is still all ongoing. Now, the amended answer, this is the latest filing by Travelers. This was filed in April. An answer by Travelers. They were just like, all right, we missed a couple points. Thank you very much, Viking. Let me take care of one housekeeping issue just real quick. Viking, you are officially, by popular request, you've been very patient, by the way, and I very much appreciate you. You asked to become a moderator a while back, and this has nothing to do with the super chat, by the way. This just reminded me. Hello. She has been a wonderful judge at our mock trial, and she has been requesting for quite some time to become a moderator. So welcome, Viking Wolf. You're officially a mod. So you got the blue wrench. You got the blue wrench. Congratulations. And there's been a lot of support as well. Thank you to B Flair and Karen, Just Laura, Mad Scientist, Chunky Monkey, Rebel Bird. All right. KS. Oh my God. Yes, you finally got it. You finally got it. You've earned it. You truly have. I don't just hand out wrenches. For those of you who know me, have been on my channel for a while, you know I don't just hand. Some people hand them out like candy. Some people are very greedy with them. I choose. I pick and choose my moderators very carefully, or at least try to. Oh, and Alexander, I have not forgotten about your package, buddy. It's on my to-do list. We're gonna do a live opening of your package on stream. He asked me. He sent me, just for those of you who are unfamiliar, Alexander, this guy right here, sent me a package from Canada. I'm hoping it's not anything nefarious and that's going to destroy, poison, kill, or in any way harm myself or my surroundings, which I highly doubt. Alexander's cool. He sent me a package. It's sitting in my closet. It hasn't blown up yet, so I think we're good. Hasn't rotted all my clothes in the closet either, so that's good. One day we're gonna do a live, and I'm gonna be opening his package live on stream. I just have to make sure that he's on because it's his package. I want him to see my reactions and everything. So it might be gummies. I don't know, Mark. It's a big package. It's literally like you can't see. It's like this big. Tim Riggs says, for the life of me, I cannot see how they can get past the lack of standing question. Don't forget to like this video, comment below, subscribe to the channel. They had nothing in writing with the other company. Well, and that's the allegation, that they did have something in writing, Tim Riggs. With Travelers, although they have not shown the receipts yet, they're alleging that there was something in writing when New York Marine said, yes, we will be paying for the defense. And they did. Obviously, they just wrote a check for $250,000 almost in January of 2022 to Travelers. So they did pay for something, obviously. New York Marine's contract is only with Amber Heard. So how did they have standing? And that's the allegation, that they had a contract with Travelers. That's how they have standing. 2B Flair is absolutely convinced that it is going to be a bomb and it's going to blow up in my face, and then I'm going to die. Oh, thank you, 2B Flair. All right. So, to conclude, the answer by Travelers, they're like, all right, we kind of forgot a couple things. They admit, deny, standard stuff. And then, in their first cause of action, New York Marine did not owe a duty to defend the insured through independent counsel. they're pretty much admitting a couple, denying everything. Is there gonna? I don't think there's gonna be anything other than admissions and denials and affirmative defenses that they did not fail to state a claim, and they're requesting the award to Travelers by the court for its costs, the relief it seeks in the complaint, awarding ProSite, New York Marine, nothing in its counterclaim, and any and all other relief that may be required. Okay, well, that was a quick one. I didn't realize that it's just gonna. This is just their basic answer. They didn't. I mean, there's really not much to really counterclaim there, is there? So that's it. And now things are moving forward on both lawsuits. For those of you unfamiliar, both of these are still alive and well today. The last filing was due last Friday on the 13th, and I believe New York Marine asked for an extension in their suit. And they're both basically outlining a whatchamacallit, the word is literally escaping me right now. It's on the tip of my tongue. A conference, a scheduling conference. There we go. Let me show you guys. A scheduling report has been entered. And this is what it says. These are the dates that they have basically both agreed upon at this juncture, okay? By October 31st of this year, both parties will complete discovery. That's New York Marine and Travelers and Amber. And by October 31st, they will hold private mediation and let the court know within 10 days of the decision if there's been a settlement or not. There's going to be a status conference in November, expert disclosure and expert cutoffs for both sides in November and December of this year. And then a year from now, next January and next February, rather, that's going to be the expert cutoff. March of next year is going to be the last date to file all motions, including discovery motions. And right before tax day, they're going to have their final pretrial conference and probably decide on a trial date if they can't resolve the case. So that's basically where they're at. Tam Riggs says, I would also like to point out how toxic AH is. She has accomplished getting 2 insurance companies fighting each other over her. Yeesh. Morgan Tremaine did indeed own Eileen. And it is British Blue. I mean, it's a very long and drawn out process, isn't it? And this is standard. Sadly enough, this is standard. If we do have a jury trial date, it will literally be like next August, maybe next September, about like 22 months from now. That's not uncommon at all. So yeah, that basically catches us up. I'm going to keep tabs on the insurance stuff. You now have a complete picture of both sides, New York Marine versus Amber and Travelers versus New York Marine. It's a love triangle where Travelers is the BFF, Amber is the toxic, and New York Marine just doesn't want to pay. So thank you all for joining me. Don't forget to like this video, comment below, subscribe to the channel, and I will see you all tomorrow. Bye, everybody.